Morning, everybody. Thanks very much for joining us on this rather, certainly here in Birmingham, rather nice, bright and sunny morning. The session, as I'm sure you're all aware, is an update on immigration issues as they affect universities. I'm going to broadly divide the session into two. We're going to look at student immigration issues, so issues for those of you working in admissions and working with international students. We'll talk a bit about the graduate route and the high potential individual route, both of which are visas aimed at graduates, and that will sort of segue from students into skilled worker and other work-based immigration categories. So second half of the session will be focused more on those of you working in university HR functions. Finally looking at right to work checks and issues associated with that. So as far as changes to student visas are concerned, I feel this is something of a, I feel that we've sort of maybe slightly missold this part of the session, because there hasn't really been an awful lot of change in the last couple of years or so. As you'll see from the penultimate bullet point, the student sponsor guidance hasn't been updated for over a year, and there have been some minor technical changes to the rules, but nothing really to be particularly exercised about. There are some changes which I'll discuss, but for the most part, as I say, it's a question of what's going on in practice rather than what's been changing as far as the rules or the guidance are concerned. In terms of substantive changes, we're still operating under a regime which was, to a large extent, or certainly as the headlines would have had it, reformed in October 2020 in the run-up to the end of the Brexit transition period, when Tier 4, as we'd known and loved it since 2008, was replaced by the student and child student immigration routes. But for the most part, those were primarily cosmetic changes in terminology rather than changes to the actual operations of the immigration rules or indeed the sponsor guidance. Some substantive changes, and some of which have been quite useful. Student visa applications submitted overseas can be now submitted up to 6 months before the course start date. It used to be the case that we had to assign the CAS and then wait until 3 months before the course start date for the student, until the point where the student could make their visa application. Now that's no longer the point. If we put the case where students are applying for September entry, for example, you can give them their CAS in March, and that gives them plenty of time to make their visa application, hopefully getting out of the way any problems that might arise if applying later in the summer months. Not that that will stop those late applicants, of course, as I'm sure those of you working in admissions would have been dealing with. Quite interestingly, and perhaps of some use for students where they're moving maybe from study at undergraduate to postgraduate level, where they make their visa applications from within the UK, they're now no longer subject to a financial requirement if they've been in the UK for a period of 12 months or more. So that may be a reason, I suppose, to try and encourage students to make in-country applications in those sorts of circumstances, because, as I'm sure most of you will have experienced, finances is always a big reason for the refusal of student visa applications. So if we can do away with that requirement by applying in country where eligible, then that makes a big difference. A big change over the last couple of years has been the introduction of e-visas, and that's something that those of you working with students applying from EU countries will have experienced. They now apply using ID check app, and so instead of having to attend a biometric enrolment appointment and getting a biometric residence permit, instead they enroll their biometrics, prove their identity using an ID check app, and then instead of getting a biometric residence permit, they get an e-visa, which you have to check online. So that's a big sort of practical change that we're all having to get to grips with. and that's something which we'll see increasingly over the coming years as the government moves towards its ambition of an immigration system that's, to use their words, digital by default. In other words, everybody has some sort of electronic status rather than physical documents being issued. The visit rules were reformed back in 2020, so that there's now no longer a short-term study visa for students coming to study on courses that are less than 6 months. That study can now fall within the visit rules, which means that you don't have to worry about those students getting a specific or a particular type of stamp on arrival at the border. Anybody who's here as a visitor can enroll on a course that's up to 6 months in duration. Something that was very warmly received just a few months ago was the removal of the police registration requirement. Something which had been in place pretty much well for decades, really. This requirement that certain foreign nationals had to register with the police following their arrival in the UK, and that extended to students from some countries as well. Well, that's now been removed, so it's no longer a condition which is endorsed on a student's visa, and indeed, where it was endorsed previously, is now something they no longer have to comply with. So an issue that would sometimes arise when a student was applying for an extension of stay but hadn't kept their police registration certificate up to date is now no longer a problem. So that's certainly something which has been very warmly welcomed. What we have seen, this again is a practical change rather than something which is change as far as the rules or the guidance is concerned, is that UKVI seem to be taking a far greater interest in the agents that education providers are working with. We're aware of lots of education providers receiving requests from UKVI, from the Home Office, asking for details of the agents that they currently work with. And so it does seem to be a greater area of focus for them. I'm sure you already do, but if you don't, then do make sure you've got robust contractual arrangements in place with your agents. And if it's a while since those contractual arrangements have been looked at, certainly we'd suggest getting them reviewed and making sure that they're up to date and offer both the university and the students the protection that are needed in the event that an agent suddenly goes rogue, because that's certainly what the Home Office are concerned about. So I've already mentioned that the sponsor guidance hasn't been updated for over a year. We're expecting some changes to the immigration rules, although again not likely to be anything substantive as far as students are concerned in the next month or so. But it might be that around that time the Home Office take that opportunity to revise the student sponsor guidance. But no, I don't have any insider gossip for you, I'm afraid, as to what that might contain. So do watch out for that. And I've already mentioned this transition over to e-visas, particularly for EU nationals, and as it says on the slide, also for students who are making their applications for extensions of stay in country. And what you'll have seen for those students who enrolled on courses that are expiring, that are ending in 2025 or beyond, is that where they are being issued BRPs, in the overwhelming majority of cases, their BRPs actually don't expire. Well, it will expire early. They'll expire at the end of 2024, and that's due to actually some EU legislation in relation to identity documents and security framework, which underpins those that the UK had signed up to, and so as a result of which had agreed not to issue biometric residence permits which didn't comply with that legislation beyond the end of 2024. We're still complying with that legislation, but the government are using it as an opportunity to move over to this digital immigration system. And so at some point during 2024, there will be further news about what will happen to foreign nationals who hold BRPs that should expire beyond the end of 2024. Now, it might be that they're just told, well, you've got a digital immigration status, and that's what you can rely on from now on. but actually the full transition to e-visas isn't expected to take place until the middle of 2025. So for some people, particularly visa nationals, people who need a visa to come to the UK for any purpose, it might be that some temporary measure has to be put in place until the full digital border is up and running. So again, something to look out for. And in particular, if you've been concerned about BRPs expiring earlier than they should, there is a reason for it, and it is actually by design rather than by mistake. Just a few more notes on the issue of EU nationals, and in particular education providers, student sponsors' duty to check the immigration status of its international students. Since July 2021, last year, universities have been required to check that unsponsored EU national students have an immigration status that allows them to study in the UK. That might be status which was granted under the EU settlement scheme. It might be status which has been granted as, for example, the dependent of a worker, someone who's a parent who's here on a worker visa, or it might be indeed that they've been granted their own student visa, in which case they'll have a digital status. So since that date, universities which hold a sponsor license have been required to carry out these right to study checks on EU students in the same way that they were on other international students before that date. But the sponsor guidance confirms, and this is one of the changes that was actually one of the last updates to the sponsor guidance that we received, was confirmation that there was no requirement to do a retrospective check on an EU national student who was enrolled before that date, before July 2021. So if we're following the usual, if I can use that term, academic calendar, EU students who enrolled in September 2020, as an institution, you can essentially assume that they sorted themselves out, that they made their application as they were entitled to under the EU settlement scheme, and that they therefore have a right. You don't need to go back to those students having checked their national passport or indeed their national identity card. You don't then need to go back and check that they made an application under the settlement scheme. That's something you can assume under the guidance. Where it does come to light that an EU student who's trying to enroll on a course hasn't made an application under the settlement scheme, if they can produce a certificate of application confirming they've made an application but not yet been granted status, then that can be used as a confirmation that they have a right to study. And then once their status has been granted, then they can provide you with a share code, and you can access their digital immigration status or their e-visa that way. One thing that those of you who've been checking digital immigration status might have noticed is that it doesn't, when you're checking someone's right to study using the Home Office's online service, it often doesn't tell you all of their immigration conditions. If they've shared their immigration status in a way which just provides the person making the request with proof of their right to study, it just says, and this was certainly the case last time I looked, that they have a right to study until, and then the date that their visa expires. Whereas if this is a sponsored student, someone who's got status, having assigned them a CAS and applied for a student visa, one of your sponsor duties is to check that they've been granted permission with the conditions attached to their condition are all correct. And that would include whether they've got the right, whether they have the right to work or not, whether they have been granted that correctly or not. So the share code that you get to confirm right to study doesn't allow you to do the remainder of those checks. So where that's the case, well, one thing to say is this has been brought to the Home Office's attention, and I understand that they're looking at a fix to try to update the online checking service. But until that fix is put in place, then it may not be a bad idea to also obtain a right to work share code as well for those students, so that you can check that their work conditions have been granted correctly in line with the guidance and indeed the immigration rules. Something that's very topical for me at the moment, although perhaps less topical for most people, are the COVID concessions. I perhaps won't dwell on this too long, because the headline is this has all ended. There really aren't any COVID concessions in place anymore. There were concessions around distance learning, blended learning, extended periods outside of the UK for students who'd already been to the UK enrolled and then gone home. Various concessions relating to reporting duties, record keeping duties, and so on. But those pretty much all came to an end on the 30th of June, where a student was on a student visa and was outside the UK. Distance learning, the requirement was that they had to return by that date. Blended learning was also required to stop by the 30th of June. One thing you might want to do, where some students benefited from some of those concessions around reporting changes in location, the guidance did say that you should make a note on the file of each student affected. So maybe just go back through your student files just to make sure that the appropriate notations were made on file, and that you confirm that you were relying on concessions. But otherwise, certainly if a sponsored student, if you have for your university's sponsored students, they all are now required to be back in the UK and fully engaging with their studies. Which takes us on to the changes to the engagement or attendance monitoring duties. So again, this hopefully won't be news to most of you working in this area, because it's something which has been enforced now since we had these substantive changes to the Tier 4/student rules, well, over 2 years ago now. So instead of what we had previously, which were attendance monitoring duties, instead now what we have for HEIs, for universities, is a requirement to monitor academic engagement. And there are various standards which are applied depending on the level of the on the level of the course. For those courses at degree level or above, essentially the university is allowed to set its own policy, which sets out what will be monitored, minimum levels of expected levels of engagement, minimum levels of engagement that students on those courses are required to demonstrate. And your policy can vary the requirements by courses, different types of course, different levels of course. So there can be quite a bit of flexibility within that. But the really important thing is that you must make sure you have a policy which sets all of this out. And I'm not going to go into the detail, but the sponsor guidance then sets out the things that is required within those policies. There is a maximum period set out within the guidance of non-engagement, which is before the university then intervenes and takes steps to try and resolve the students' poor engagement, or indeed remove them from the course and withdraw their sponsorship. And that is a period of 60 days. So that absolutely has to be enshrined within the policy. And then there are also within the guidance alternative arrangements which needs to be in place for courses below degree level. So those of you sponsoring students to study below degree level, we've still got this requirement for a minimum of 15 hours daytime classroom-based study per week, and a process for monitoring and reviewing that. And steps to be taken, the policy must outline the steps to be taken where attendance, and that's what's being monitored here, really falls below 85% in a month, and then a requirement to withdraw sponsorship if it falls below 70% for 3 consecutive months. There is a new reporting duty, and this will again lead us on to the next heading, which is for those students studying at bachelor's degree or above, where your university has a track record of compliance, and I dare say the overwhelming majority of you attending today will do. There is a requirement that you report graduates who qualify for the graduate route through the sponsor management system. So that's now actually set out as one of your reporting duties, and that's because that report is required by the students following graduation, should they wish to make an application under the graduate route. So we'll come on to the graduate route in a moment. The final point I just wanted to touch on, and this is something which has come from some stories we saw in the press earlier this summer, is and we'll talk about the detail on the next slide, but would just be to think about whether your admissions or engagement policies think about the risk of exploitation that international students in particular might be at by virtue of the fact that they're in a foreign country, a long way from home, probably without any family here, perhaps without a close circle of friends, and so perhaps therefore more at risk to exploitation. And the reason for that is this sort of rather sad story that was reported over the summer, where a number of universities were reported to have international students who became victims of human trafficking, effectively of labour market exploitation. And the full details weren't really published, but reading between the lines, what appears to have happened is that international students having a right to work have taken jobs, and then, as far as we can tell, have been tricked into breaching those restrictions, so breaching the 20 hours a week that they're restricted to, and then effectively being blackmailed into working longer hours for less pay, sometimes even no pay, under very poor conditions. So people taking advantage of the fact that these people are sort of terrified for the fact that perhaps they're going to have their student visa revoked. So it's one of those things where it's very difficult to advise on a sort of general basis what a university can do to prevent that. But I do think that, as I said just a moment ago, thinking about whether your attendance, engagement, even your admissions policies address the possibility of those sorts of things happening. And we have this renewed requirement to ensure that we're monitoring engagement of international students, and where a student's engagement is dropping off, that could well be a sign that perhaps they have become a victim of human trafficking. So do think about it within that context as well. So there's certainly a welfare issue to consider, and where this sort of thing does arise, it doesn't necessarily mean that you are in breach of your student sponsorship duties, but you obviously have a duty of care towards those sorts of to students in that situation. And I suppose also to think about whether there might be any other students who are also at risk, so maybe within their circle of friends or on the same course, to think about whether there might be any other students who have also become victims of the same thing. So again, just something to think about. Albeit I can't offer any sort of I can't offer a silver bullet which is going to stop this, but do have a think about it. And then just while we're on this topic, just to think about safeguarding issues as far as students under the age of 18 are concerned. Various points highlighted within the sponsor guidance is sometimes something we see universities not giving quite as much attention to as we think maybe they should when we're talking to them about student sponsorship. A lot of universities are admitting students who are nearly 18, but not quite 18 at the point when they first come to the UK, and so there will be safeguarding issues, making sure that you've got parental consent for the arrangements, ensuring there are appropriate people in the UK to be able to look out for the educational guardians, those sorts of things. So do make sure that that's something that you're thinking about. All right, moving on to the graduate route. So not an awful lot to say. It's pretty straightforward, although obviously it's something that universities are involved with. From the individual's point of view, it's great to have a category like this having been reintroduced. It's an unsponsored work category that I suppose effectively acts as a stepping stone between a student visa and a work-based visa, like skilled worker, as we'll come on to. It has to be an application which is made from within the UK, and it's only possible after the university has reported that the individual has completed their course, has graduated. It's for graduates at bachelor's, master's, PhD level, but also to a wider range of courses, so including the law conversion course, legal practice courses, bar practice course, as well as medicine and dentistry courses and teaching qualifications. So actually open to not just students studying on conventional degrees, but also those more practical courses as well. And they'll get a 2-year visa in most cases, or where someone's graduated from their PhD, they get a 3-year graduate visa. The visa doesn't count towards indefinite leave to remain. So once the students, or the graduate rather, is on that course, they'll probably want to get off it fairly quickly, so that if they're looking to make the UK their permanent home, they can start their pathway to that sooner rather than later. But as I said, it's a great stepping stone. And of course, we had the post-study work category that was scrapped years and years ago, and so it's good to have that reintroduced. And I'm sure your marketing departments will be very pleased that they've got that they can talk to international students and their agents about. A very similar immigration category that was introduced in May, although not really of the same nature, is the high potential individual route. And again, it looks a lot like graduate because it applies to people who've graduated from the same sorts of courses, but it's graduates of overseas universities who've decided to come to the UK on an unsponsored work basis. Now, the list of universities that they come from is pretty narrow. There's a top 50, on the slide actually it says expected, but this is now being published. There's a global universities list where they take 3 measures of the top 50 universities around the globe, and if the university in question features on 2 of those lists, then it makes the global universities list. Yeah, those graduates from those universities are able to apply for a 2- or 3-year visa, depending on the level of course that they were studying at. So not directly relevant to your graduates, of course, but maybe relevant maybe to HR teams if you're speaking to a fresh graduate from a top university, and I have to say the majority of them do seem to be in the US. But yeah, so graduates of top universities around the world looking to come in for a sort of entry-level lecturer type role. Maybe we can think about the high potential individual route rather than sponsoring them under skilled worker, albeit as with graduate, time doesn't count towards indefinite leave to remain, although again it's a useful stepping stone. So there's that. Right, moving on to the sort of nitty-gritty as far as the HR side of part of the session is concerned, looking at changes to skilled worker route. As it says on the slide, the skilled worker route replaced the old Tier 2 general category in December 2020. And as with the changes from Tier 4 to student, primarily what we had was a change in terminology, although again, some for the most part, changes which are to be welcomed, such as the reduction in the skill level, reducing the previous skill level requirement from graduate to RQF level 3, so jobs where the sort of skill level set is sort of around A level rather than graduate level requirement. More on that on a slide in a few moments. Of huge significance, and certainly something that was very welcome, was the removal of the resident labour market test. That's not to say that it's not important that you check whether there's anybody who can do the job, or indeed there's now no longer a requirement to advertise a job at all before offering it to a sponsored worker. But we don't have the same bureaucratic checklist-based tests that we had previously. Instead, now there's what they refer to as the genuine vacancy requirement. So we just have to be able to demonstrate to the Home Office, if asked, that yes, it is a genuine role, and as proof of that, here's our attempts to fill it from resident workers through the adverts that we've placed. So it's still important to keep that evidence of recruitment exercise, but we don't have to worry about it containing quite the same level of detail as the old resident labour market test. There was a cap under Tier 2 General, a notional limit on the number of sponsored workers who could be brought into the UK each year. That's now been removed, but there is still a sort of a two-step process for sponsoring overseas workers, where we have to still request a specific certificate of sponsorship for that individual, and then once it's been approved by the Home Office, assign it to that individual. So we can only do that once we've identified the vacancy, rather than drawing from an annual allocation of certificates, which we would be able to draw from when we're sponsoring someone coming from outside the UK. So still a bit of bureaucracy involved, but that process again has been hugely streamlined. Switching immigration categories is now much easier. It's much easier now to switch into the skilled worker category than it was to switch into Tier 2 General. Case in point, somebody in the UK under the Youth Mobility Scheme didn't used to be able to switch into Tier 2 General. They may have come to the university on a Youth Mobility Scheme visa, worked for 2 years. We wanted to offer them a full-time permanent role. We could sponsor them, but they would have had to have gone back to their home country and applied as though they were coming to the UK for the first time, which, apart from anything else, racked up a huge number of air miles and didn't do much for our carbon footprint where that person was from Australia. Now, instead, that person can switch from their Youth Mobility Scheme visa into skilled worker, saving air miles and saving quite a bit of hassle at the same time. We have a tradable points requirement within the skilled worker category. It really only applies to the salary requirement. So where somebody's got who's been offered a role that's on a shortage list, or they have a relevant PhD, we can reduce the minimum salary that we're offering them. So that's where there's a sort of flexible points element to the salary requirement of skilled worker. But other than that, most of the requirements are mandatory. And I'm going to talk a little bit about the ATAS requirement, because that now applies to skilled worker and indeed other sponsored worker categories as well. So I'll come on to that in a few moments. Just to say, in relation to the skill level requirement, you'll get copies of the slides. I've just on this slide illustrated some of the lower skilled roles that previously, so the RQF levels 3 and 4 roles, which previously wouldn't have qualified under Tier 2 General, but now do under skilled worker. But important to still bear in mind, there are still lots of lower skilled roles that don't qualify at all. So if we are looking to sponsor people to do those sorts of jobs, then we do need to make sure that we are still sponsoring, the role does still fit within a qualifying skilled occupation code. All right, so I said I was going to say just a few words about the ATAS requirement. So it is something which now extends not just to sponsored workers, and sorry, for those of you not sure on the terminology, ATAS is the Academic Technology Approval Scheme. It's a way of ensuring that, I think to use the jargon, we're not exporting technologies and knowledge which could be used against the UK. It's a national security measure. So where certain courses and areas of study might be relevant to weapons of mass destruction or other technologies which might be used in armaments, then there has to be an approval by the Foreign Office. So that was always the case for sponsored students from certain countries, but now it extends to sponsored workers and including skilled workers, but also sponsored researchers under tier 5 in certain circumstances. So set out on the slide, the applicant is not an exempt national. The sponsor is also a student sponsor. So again, that will apply to most universities. The role is in a specified occupation code. So within Appendix ATAS of the immigration rules, it lists the occupation codes which you've got to apply this test to. The person's employment or their sponsored work also involves research at PhD level or above, and that area of research is a listed subject. So the same listed subjects that apply to student visas. So now we've got on the certificate of sponsorship a box which asks us to confirm whether an ATAS certificate is required. And I would say that for most universities, there's universities certainly that also have a student sponsor license, as most of you I'm sure do, then I would say best practice would be to, where you've determined that an ATAS certificate is not required, I would include some additional text on the COS which just confirms why that is the case, just to head off the possibility of any questions or worst case scenario, possibly even a refusal for not including an ATAS certificate. So the person is exempt national, or they are coming to work for us as a lecturer, but doesn't involve substantive research at PhD level, that sort of thing. So probably not mandatory within the rules, but a best practice point there. I just wanted to move on to talk a little bit about some other immigration categories that you might come across as HR professionals working at universities. But the first one is the British National Overseas visa routes. These were visas that were introduced as a result of some changes to the national security laws in Hong Kong, which the UK government have determined to be a breach of the UK-Chinese treaty, which governed the handover of Hong Kong to China in 1997. And what this visa allows is it's a fairly flexible, fairly generous immigration route, and it allows any person who holds a British national overseas citizenship, which is a form of citizenship granted to residents of Hong Kong on application in 1997, to come with their families to the UK with pretty much no restrictions on work, and unlike a lot of most immigration categories, also allows them to bring their adult dependent family members as well. So most immigration categories, the cutoff is 18 for bringing dependents. That's not the case under the BNO scheme. When it was first launched, it was an estimated 5.4 million Hong Kong residents deemed to be eligible. That's going to expand slightly. We're going to see some changes in the coming weeks to those rules. At the moment, the British national overseas citizen has to be coming to the UK with the rest of the family. But if the BNO citizen, under the changes which will be implemented shortly, if the BNO citizen decides they want to stay in Hong Kong, their adult family members who aren't themselves BNO citizens can come with their dependents. So broadening the scope even further. And as I say, it's a really useful category for those Hong Kong residents who do want to relocate to the UK. And we're seeing not just me, across, the UK is seeing a lot of people coming to the UK under this category. It's been very successful. Okay, just a few words on right to work checks, because there's been a few changes here. Changes sort of dating back to July 2021, associated with Brexit, removal of EU national documents confirming right to work, as you might accept, that being the end of the Brexit, or the grace period following the Brexit transition. Since April this year, hopefully you're all familiar with the idea now that somebody who holds a biometric residence permit or biometric residence card can't use that document on its own to prove their right to work. That person will have a digital immigration status that sits alongside that physical document, and it's that digital status that you need to check in order to confirm their right to work. So you need to get them to provide you with a share code, and then you use that share code as the screenshot on the slide for your job applicant's right to work details. You use that portal, the Home Office checking service, on gov.uk to view their e-visa, their digital status, and that can be used, and that's what stands as your right to work check, rather than the biometric card itself. Also in April, the government started to introduce the use of checks conducted by or with the assistance of IDSPs, identity service providers. So that's for somebody who holds a current British or Irish passport or an Irish passport card. And where that's the case, the IDSP can check that person's identity, verify their identity against the passport databases in order to confirm that person is a British or Irish citizen and therefore has the right to work in the UK. And then 30th of September was the end of the COVID-19 adjusted checks on conducting right to work checks. So under those adjusted checks, you didn't need to see a physical document. The person could provide you with a scan of their British passport, for example. Now we have to see the physical documents again, unless we're going down the IDSP route. All right, so just going through some of your questions. First one from Anonymous. Actually, I'm not going to read your names. That's mean, but this one's anonymous anyway. We've had problems with delays to ATAS being issued. Is the sector, legal firms, raising this issue with the government to try and get them to better resource this department? I don't know. I mean, that's probably one that's best asked of Universities UK or other representative bodies. I'm not aware of any challenges or any sort of formal queries being raised about there being better resources, or indeed what the issues for delays are. I have to say that my experience is that in most cases, it's a bit like me and cars. I don't look under the bonnet. I'm not allowed to look under the bonnet. We're not privy to what goes on as far as ATAS assessments are concerned. So, yeah, sometimes there are delays, and it's not because the department is under-resourced. It's because they're doing lots of very detailed checks on this particular person and their area of research. So I can't say for certain what the reasons for the delays are, but we are hearing of delays, and I would suggest probably raising that with Universities UK if it's something that you're experiencing, because it probably requires a coordinated sector-wide approach. Next most popular question: any advice on verifying right to work checks for external examiners who do not come onto campus? Well, this is a very frequent question that I get from universities, and of course, while the COVID concession was in place, that provided us with a pretty useful way of being able to do those checks. I don't think I have any really good advice for you, because I'm probably just going to sort of parrot what the Home Office would tell you, which is there are now mechanisms in place for doing right to work checks remotely through IDSPs. So you could do that. If the external examiner is a BRP holder or otherwise holds a digital immigration status, then you can ask them for the share code and you could have a video call with them. So it's still possible to do the imposter check. So I'm not looking directly at you, I'm looking at my questions. It's still possible to do the imposter check via a video call, but you need to see the original document. So if the only document they've got is a British passport and you're not signed up with an IDSP, or that British passport has expired, the only way to do the check on the document is to do that check on the physical document rather than seeing a scan of it. So you could, but I can't imagine anybody taking me up on this, you could ask them to post you their passport so you can examine that you can check that it's not been tampered with, etc. And then you could have the video call with that passport in hand in order to verify their identity, so they don't need to come onto campus. So that's still possible. You're still able to do that bit, but they would still need to somehow get their physical document to you. If they're a BRP card holder or otherwise got an e-visa, again, get the share code. You can have the e-visa up on screen and have the video call with them, so you can do it that way. But where somebody isn't prepared to post you their passport, then probably the only way is to see is to somehow get, and you're not signed up with an IDSP or it's an expired passport, then the only way is to get them to come onto campus with their passport, unfortunately. All right, next. Student visa change. So individuals coming into the UK for short language courses up to 6 months can do so on a visitor visa. So yeah, absolutely right. They can either, if they're a non-visa national, so someone who doesn't need a visa to come to the UK as a visitor, then they can turn up at the border and be granted entry as a visitor. And as part of their standard visitor conditions, they can study on a course of up to 6 months duration. The crucial point there is that the course cannot be more than 6 months. It absolutely is not the case that somebody could come in for a term as a visitor and then go home for the holidays and then come back, because if the total course is more than 6 months, then that would be a breach of the visit rules. But yeah, a short language course absolutely is possible. And then we've still got the short-term study visa, where it's an English language course of between 6 and 11 months, if that's something that you're also offering. Thank you for that. Random question. I like those. But I can't find the answer in the immigration rules. If someone is granted a permitted paid engagement visa, are they able to come and go from the UK during the visa period, or does their leave lapse once they leave the UK? Well, a permitted paid engagement is part of the visitor rules, and it only allows somebody to come in for a month to do a specified type of engagement for which they may be paid. Now, I am pretty, now somebody coming in on that basis can't use the e-gates, for example, if they're a non-visa national and could otherwise come in without a visa for the visits. They still need to see an immigration officer because they need a stamp in their passport which confirms that they are here for a permitted paid engagement and the length of that. I would need to think about it more carefully because I suspect there's all sorts of other bits of legislation in play. I have a suspicion that it's lapsing leave, which means that on exit from the UK, it would lapse and they would need to be granted entry permission again under the permitted paid engagement rules in order to resume that paid engagement. It's not an issue that comes to light very often because it is only ever for a month anyway. But yeah, where it is somebody who is needing to travel during that month, I'm pretty sure they'll need a new stamp in their passport on return to the UK, because the duration of that leave means that it will have been granted as lapsing leave rather than non-lapsing leave. That's certainly my on the hoof answer, but I need to do a bit of research to get the chapter and verse on that. Next question: student wishing to move to graduate visa, if they haven't passed their course yet and have extenuating circumstances, the outcome of the EC, extenuating circumstances, I guess, is a couple of weeks after the EC assessment outcome is known. What can they do to extend their student visa to cover this short period? Can't see anything in the immigration rules, and the student has been able to get through to the helpline. That's quite a specific query, and what somebody can do in those sorts of circumstances, and this is probably absolutely, this is something that somebody should get specific advice pertaining to their particular circumstances. But if somebody was to make an application before the expiry of their leave, they benefit from Section 3C of the Immigration Act, which protects their status while their application is pending, and indeed throughout any appeal periods that might follow should the application be refused. While someone's application is pending, so before a decision, before it's been considered, before it's been determined, they are then able to put in a variation application should there be a change in their circumstances and they wish to change those, change the original application they've made. So one option might be, but this is not, I mean, absolutely, they should not do this without advice or on the basis of what I'm saying today. They need to get particular advice about their particular circumstances. But one option that occurs to me would be to put in an application which protects their status while they're waiting for the outcome of their degree to be known and for the university to report that they've graduated via the SMS. And then once that's been done, to then put in a second application varying the basis of the first application to a graduate application on the basis of the application. So that might be an option that they can go. Now, that's not something which is set out within any guidance. Well, actually, there is guidance on making variation applications and considering variation guidance. So it's guidance for caseworkers, but that's not something you're going to see on gov.uk or even in the rules, because it's a sort of it's a way of, well, I'd say winging it or using the legislation to sort of to assist you. But as I say, you know, please don't do that if it's not something that you're particularly familiar with doing or haven't had specific advice on, because it may be that that particular person's circumstances mean that's not a suitable approach. But that's something I would be considering if that was someone I was advising. All right, we're nearly done. I'm going to try and get through a couple of these additional questions. I'm not going to have time for them all because we are at time. But thank you very much for posting your questions. It was good to have some engagement. Another question on ATAS: is the list a cumulative and, or is it or? Thank you. That list on the slides, it's and. So the sponsor needs to be a student sponsor as well as being a skilled worker sponsor, obviously, and it needs to be a role in one of the specific occupation codes, and the research needs to be in a particular area of research at PhD. So it's all of those factors, not just all. So thank you for that. Do visiting academics who are not sponsored require an ATAS if subject is relevant? So visiting academics under the visit rules, I can't think off the top of my head. I don't think there's an ATAS requirement in there. It will say either in the visit rules and or appendix ATAS of immigration rules if ATAS is required. I don't think it is though, but thank you. Just a couple more. We're experiencing significant delays with visa processing for a number of different routes, including skilled worker, startup and graduate. If someone submitted their application before priority was reinstated, could they submit a new application for the same route, but pay for priorities to get a quicker decision? Would this still counts a variation of leave if it's the same route? Yeah, it remains the case that it's not possible to upgrade an application from standard to priority after it's been submitted. I suppose variation might be a possibility. It would require submitting the application again, paying the fees again, and then getting refunds on the earlier application, which will obviously leave the person out of pocket for some time. But that's a possibility. I've not done it though, so that's my answer on the hoof rather than having thought it through very carefully. Okay, I'm just going to do two more. We do not use an IDSP at the moment, but have problems with right to work checks for external examiners who don't visit on campus. Oh, actually, I've already answered this, so I'm not going to answer that one. When checking someone's share code for proof of right to work, do you need to insert a text box on the PDF to confirm the name of who conducted the check and whether it was done in person or on video call and the date the check took place? You don't need to do those things. I think it's good to record that information somewhere. Doesn't need to be on the PDF. It could be somewhere on your HR database or on some other form that you're filling in as you're going along, or indeed, yeah. But it's not a requirement to have those on the PDF, and it doesn't say you have to record those things. The only thing you are required to record is the date on which you did the check. But you know, name of who did it, confirmation of how they did it, are all best practice points. I definitely would advocate doing that. How you record that though is up to you. One more. Can recruitment agencies undertake right to work checks for agency staff on behalf of an employer? Well, if it's agency staff and they are technically employed by the agency, then it's up to the agency to do those checks. If it's an agency placing those people with you, and so the agency remains their employer, then it's up to them to do the checks. But if they're effectively acting as a headhunter, or we've got a temp to perm type scenario where they become your employee, then you can't rely on the checks that the agency's done before they become your employee. You need to do the right to work checks in the usual way.